Understanding the Don Donut Rule for trademarks. In trademark law, the general rule is that where two parties seek to use the same trademark in the same geographic area, the earlier, senior user has rights superior to those of a subsequent, junior user. However, under the Don Donut Rule, if the use of the marks by the registrant and the unauthorized user are confined to geographically separate markets, with no likelihood that the registrant will expand his use into the defendant's market so that no public confusion is possible, then the registrant is not entitled to enjoin the junior user's use of the mark. In 1959, the Second Circuit noted that plaintiff Don Donut Co. Inc. of Jackson, Michigan since June 1, 1922, had continuously used the trademark Don on 25 to 100-pound bags of donut mix it sold to bakers in various states, including New York. Plaintiff's marks were registered federally in 1927, and the registration was renewed in 1947. The defendant, Hart Food Stores, Inc., owned and operated a retail grocery chain within the New York counties of Monroe, Wayne, Livingston, Genesee, Ontario, and Wyoming. It sold and advertised donuts and other baked products within 45 miles or Rochester, New York. Hart first used the imprint Don on its packaging stating in 1951. The district court had dismissed both plaintiff's complaint for infringement of its federally registered trademarks and defendant's counterclaim to cancel plaintiff's federal registrations. The question before the Second Circuit was whether the plaintiff, a wholesale distributor of donuts and other baked goods under its federally registered trademarks, Don and Don Donut, is entitled under the provisions of the Lanham Trademark Act to enjoin the defendant from using the mark Don in connection with the retail sale of donuts and baked goods entirely within a 6-county area of New York State surrounding the city of Rochester. The court concluded that, because no likelihood of public confusion arises from the concurrent use of the mark in connection with retail sales of donuts and other baked goods in separate trading areas, and because there is no present likelihood that plaintiff will expand its retail use of the mark into defendant's market area, plaintiff is not now entitled to any relief under the Lanham Act, 15 U.S.C.A. Section 1114. Accordingly, we affirm the district court's dismissal of plaintiff's complaint. However, this doesn't mean that the defendant has any permanent right to use the mark in the area. On the contrary, said the court, we hold that because of the effect of the constructive notice provision of the Lanham Act, should the plaintiff expand its retail activities into the 6-county area, upon a proper application and showing to the district court, it may enjoin defendant's use of the mark. One area where this has important implications is with franchises. Franchise owners may need to disclose the risk that a potential franchisee may not be able to enforce its trademark rights in such state, making it unlikely that the potential franchisee will go ahead with the deal. Need help with franchising contracts? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.